Yes. Good morning, everyone. This pre-trial review is in the matter of case number CFI 72-2022, held before His Excellency Deputy Chief Justice Ali Madhani. The claimant is represented by Gately UK LLP, DMCC branch, and the lead counsel is Ms. Sarah Malik, and the defendants are represented by Clyde & Co. Lead counsel is Mr. Gavin Mansfield Casey. Thank you, Your Excellency.
Thank you, Zaid. Good morning, Ms. Malik.
Good morning.
Good morning to you. Do you want to address the court about the pre-trial? What do we have today?
Thank you. Your Excellency, firstly, I was just housekeeping matters with my learned counsel to check that there's been an updated version of the bundle, which has just recently been updated on the portal, largely to include the skeleton argument that was received yesterday from the defendant, and also to add in matters that have been contained within that statement, within that skeleton, to do with application for disclosure and also an in-person hearing. And I was just checking with my learned counsel, Mr. Kemp, whether he'd had access to that. In essence, all that's been added are about 30-odd pages, which shouldn't come as a surprise to the other side, but I know they've been emailed over, and I'm not sure whether he has that updated bundle, nor indeed the court has that in front of them. So may I query that, please, first?
Yeah, from the court side, I do have them. They are before me from this morning.
I'm grateful. Mr. Mansfield?
Your Excellency, I have it just now. It's 7 o'clock in the morning UK time, so I've only seen it this morning as I logged on ahead of the hearing, but I understand what Ms. Malik tells me is in it, and that's fine from my point of view.
I'm very grateful. Your Excellency, then in that case, largely, obviously, the PTR is housekeeping matters, and my learned friend has set out within their skeleton argument what they consider needs to be looked at today. And if we kind of use that as a crib, just so I may address those points that are raised, I didn't seek to do that by way of a written document. And I'm just going to pull it up if you give me a second. So if we're looking at the bundle, if we go to page 200 and just give me a second.
Take your time.
It's always difficult to navigate the remote. Okay, the skeleton argument starts at 266 of the bundle before you. So if we're all on that page. In essence, there's 5 issues that have been raised for today, and I will, if I may, Your Excellency, seek to address you on the first one, which is the mode of trial. And I caveat that by saying I fully understand and accept that a few weeks ago, and there was ongoing kind of correspondence between the parties or the court to say, may we please have this in person, and the court updated us a few weeks ago. Your Excellency, that is something that we do bring to your attention again, and if you may indulge me, I'll explain to you why. You may well be aware that this case, well, there were 2 cases in effect that were brought against the same defendant. One of those cases, which was being dealt with by your learned colleague, Mr. Justice Black, which was the only reason we asked that he keep the matter, as he had some background. No issue at all, Your Excellency, for you to have the matter. That matter was, for the very same reasons, listed in person. And the reasons are, Your Excellency, that this is a case, and my learned friend I see within the skeleton argument has referred, for example, to protocols, even those of the DFC courts, and indeed we know the international protocols. And every one of those protocols and practice guidance notes does set out that the efficiency of witness examination, especially where there are factual issues, there's real kind of factual diametrically opposed events or version of events. And this is a very important case in terms of cross-examination. There are a number of witnesses. It's a matter that goes to race, discrimination and whistleblowing and makes jurisprudence for the DFC courts. Once we look at the overriding objective and the need for parties to be able to effectively put their case, for the court to see the demeanour of the witnesses, for the matter to be as efficient as possible, and even taking account of the fact that witnesses are based elsewhere, well they were in a previous matter, a linked matter. Those witnesses can be flown in. There is enough time. It is in January. And we do ask the court. I take on board that the default position nowadays in various courts and arbitration hearings is that a remote hearing should take place, unless, of course, the actual nature of the hearing dictates that an in-person hearing should take place. And I know with the DFC courts that they do encourage where there are multiple witnesses and there are multiple factual issues to be determined where parties are diametrically opposed. Those are exactly the matters that are put forward for in-person hearing. That is the reason we requested, and we do repeat that request today, Your Excellency, and I thought it would be better to raise it today, given I can make submissions on the matter. And if you're with us for that, then the whole protocol for remote witnesses, which my learned friend has put forward, but without attaching the actual guidance from the DFC courts nor the practice direction, which in itself mandates the court, the practice direction does, to look at the efficiency of the matter and to say that actually in-person hearings may well be better at certain points. And I can just refer to the actual wording. It says, when we're looking at video conferencing generally, it is not ideal as having the witness physically present in court. Its convenience should not be allowed to dictate its use. A judgment must be made in every case in which the use of VCF is being considered, not only as to whether it will achieve an overall cost saving, but whether its use is likely to be beneficial to the efficient, fair and economic disposal of the litigation. That's a practice direction. My learned friend has put a skeleton but not referred to the actual schedule or the practice direction. And I do urge the court to look at that because, as I say, in a similar matter against the defendant, which has since been resolved, it was listed for a hearing, and it was listed for the very same reasons we put forward. And that's my position for the mode of trial and protocol for remote witnesses. In respect to the trial timetable, I can be short. You will see, and my learned friend may have missed it, but the order from your colleague, and that again appears in the bundle at page, and if you give me a second to navigate, at page 200 and it's at the 200 and I think 39 or 40, just give me a second. The case management order of Her Excellency Justice Maha Al-Mahiri at page 239 of the document. It sets out an agreed reading list along with an estimate of time required and an estimated timetable for trial shall be filed by 4 p.m. on 15th January 2024. And of course, that's correct, because once we have all the reply witness statements, once we know exactly what everybody is saying, and once advocates have been able to go through all of the documents, including any additional documents that may well be disclosed, we're in a much better position to know exactly how long we need with the witnesses. And once that is balanced with the need for the witnesses to know when they need to be available, well, firstly, they need to be available for that week. But secondly, in terms of the and my learned friend makes much more of it than it needs to be. You'll see that yourself, Your Honour, when Your Excellency, sorry, when you look at the actual discrepancy between the timetable between the parties. It's really a non-issue at this stage. That's the point we make, because the larger issue, and you'll see from our application for additional disclosure I'll come on to, is the calling of the witnesses and which witnesses are actually being called. And it's the defendant's position that they're no longer calling or need to hear from their own grievance manager, who's probably, and that's a matter for them not to call him, but who's best placed to give evidence to this court. And to that end, Your Excellency, I take you to the witness statement of my instructing solicitor, which appears before you in the bundle. And again, if you just give me a second, I'll find the relevant page. That's at page it starts at page 257. And if we go on to look at paragraph 13 at the bottom of 260 and 61, we look at Mr. Richard Houghton, who's not being called, and his name appears within the timetable. What happened in essence was no witness statement was given to us. We were then told by my learned friends instructing solicitors that Mr. Houghton would be giving a statement in response. That no longer appears to be the case. But Mr. Houghton was the grievance manager during the grievance investigation meeting, and his own evidence and his own position is that the grievance filed by my client, Mr. Mohammed Lawal, has a lot of overlap with a previous grievance, a matter that I've already indicated to the court that was to be heard previously by way of an in-person hearing at these courts and has since resolved by Chris Adeniyi. We say that that witness is important. It's up to, obviously, any adverse inferences the court may well draw for that witness not to be called. But I think that's the larger issue for the other side, rather than the discrepancy in the timetable, which in essence can be sorted just before the trial, as my learned friend knows, is a usual protocol, and given that an order has already been made to that effect. So if I may then just turn finally to the other outstanding points within the skeleton argument, which are the application for document production and then the defendant's application, which seems to want to piggyback from ours for us to, we've made a formal application and they want to then address matters or documents they want within that application. From that, I'm taking that they are not objecting to the application, they just want it listed. Again, that's a costs issue in terms of listing this for a full hearing. We have asked for that application to be dealt with by paper. The application is before you, and it's in these documents as well. And all of the documents we ask for go to the issues in the case. This is an important case of harassment, race discrimination, a toxic environment, which is spelt out. And those grievances that we asked for, including a previous one that has since resolved by way of it's not had a litigation hearing, are very pertinent and relevant for the court to see. Any objection is not actually understood, and as the defendants well know, that those documents have already witnesses have had sight of those from previous matters in any event, so they can't be unseen to that effect. Now, I await my learned friend's position on those documents, but I think they raised an issue in relation to one of our mitigation documents of why is it redacted, and we immediately forwarded an unredacted version. Your Excellency, when obviously led by the court, but I've always been taught at the bar that if there's documents that assist or undermine a party's case, they ought to be forwarded. There is no issue for the parties unless you make it into an issue. There is no cost saving in having a full-on hearing for this application. It's a very straightforward application, and we ask that the court indulges and request that those documents are forwarded forthwith. The bundle can then be prepared accordingly on the 18th, and we do ask that the matter is in person. If you're not with me on that, then I'll address you at a later stage on the need for the remote witness timetable and the protocol. I'm very grateful, Your Excellency, unless I may assist you any further.
Yeah, Ms. Malik, thank you very much. What I understand, first of all, I do not underestimate your case, the harassment and discrimination case. We know we take this as serious as you take it, and we take it at the highest level of consideration. So this is assurance. I would try to cut that Mr. Mansfield time to reply to you, because I'm going to tell you the reason behind this case is not in person. It's not just because Mr. Mansfield contested. We do have a circumstances in our court. We are moving to a new premises. We are renovating our courtroom, and we are reinstating the calling system. This is going to be a really high-tech courtroom. When I took the decision whether it should be an online or in person, I can tell you this: my preference was to take it in person.
I'm grateful.
Giving the consideration the all circumstances surrounding this kind of cases. However, I was advised by my IT department the courtroom might not be ready. It might be ready, but it not be ready to take a full week, a full occupation of the case. We might have a sort of problems, and the then the decision was, why should we trouble the parties? Why we should call them? Why should we call witnesses from overseas? And this is going to be the first trial that's going on into that new courtroom, or even the other smaller courtroom. Both of them will be an installation of completely a new system. So the problem is that the court are not 100% sure the courtroom will be really ready. We don't want to get into a problem. We don't want to extend the timetable. We have witnesses coming from overseas. That's going to generate a lot of case. So this is really my decision, and I as you may know, with this kind of decision, we usually do not give a written reasons to the parties, but I'm explaining to you what was really happening. It's not about, I tell you, my initial takeaway from the case management is this kind of case is supposed to come. I mean, I personally prefer to see witness eye to eye.
I'm grateful, Your Excellency.
But I have seen that kind of difficulties. I said this is again based on advice of the administrator of the court and the head of IT. The court might not be ready by that time. It might be, but you know, the time when I have to take the decision at 5-6 weeks ago, I was told it might not be ready. So until today, the premises is not ready. The courtroom is not ready. So still, I cannot decide even now. And as you may know, you need to prepare. This is I said, it's a complex case. It's concerned a lot of witnesses. I mean, counsels flying over. It's a risk I personally don't want to take. And I hope you understand my position.
Your Excellency, we had thought as much, in fact, when we received the email from the DFC court saying that everything would be remote till at least December. We had actually internally discussed whether the reasoning behind not having an in-person was because the courts may well not be ready. So I'm grateful for that indication that otherwise it would have been in person. And then, event, Your Excellency, I suppose the only other option would be to forward and have this heard at a later date in February, or otherwise when the court is definitely open. And I'm not sure, and I haven't taken instruction, or nor do I know from the court's position where they would. The reason I say that, if there is just a couple of weeks delay or otherwise, but in fact we can have people in person, it may well be the better course of action. Again, I say that without taking instruction, without having had the benefit of speaking either to my instructing solicitors or to the client, but I just put that out there.
I say you say an alternative basis that we can move like 4-6 weeks and then have it in person rather. Yeah.
Your Excellency, given it appears that the court's on the same page as we are in terms of the importance of having this in person, but again, I do, as I say, I do need to. This is just me sounding out without having spoken to my solicitors or the client. Whether a 4 to 6 week gap would make a huge difference in their overall timetable of things, and had this matter listed so it can properly be heard efficiently within the new court in person, as it ought to be, may well be something that the parties could consider with the direction of the court.
Well, again, speaking frankly, I personally can accommodate timetable up to 21st of February.
Okay.
But from 21st February, I'll be again in holiday, and I have prepared to travel abroad. And yes, up to 21st of February, I'm willing to accommodate. However, I can see a lot of complexities. I can see council timing. We gotta have Mr. Mansfield QC with us here and his team. Then we gotta know this might be really short notice for the council, for the witnesses. But if your opponent would agree, I definitely agree to accommodate it. But let's hear from Mr. Mansfield, and then we would. The other point is that it's really striking. I mean, about your application to produce a document. I mean, do you think this is a bit late application to make, Mr. Malik? But yes, at this point. I mean, well, maybe the extension would help you to get this sorted out. But if there's no extension,
I appreciate the point, and you're right to raise, Your Excellency. I think with the ongoing duty of disclosure, and indeed as witness statements have been exchanged or otherwise, we've received document from the other side as well that are new. And indeed, we have asked for documents. You will note that in an ideal world, everybody has disclosed everything by the time we get to statements, but matters come out as we delve deeper into the evidence of matters that do need to really be before the court. And we wouldn't obviously be doing our jobs if we didn't at the time it became pertinent raise it. So I think that's the answer to, yes, I appreciate it's late in the day, but those documents are certainly documents that are not difficult to either obtain or have not, been, or the other side cannot easily forward, or indeed that, have not been subject to scrutiny beforehand. So I take the point, Your Excellency, but I think in line with ongoing duties of disclosure and as matters unfold, such applications are made. It's not for any other reason. I'm grateful.
The only concern is that the principle, if there is a point to stop exchange and production at some times. I mean,
of course,
you're not expecting any extra application from the other parties. I mean,
absolutely, and really at the time of the bundle, and this bundle is to be done by the 18th of December. That's what the court has ordered. Ideally, all documents should be before the parties then, and ideally at time of witness statement exchange. It doesn't always happen. Indeed, as my learned friends also put out, they've asked for documentation as well. I know my instructing solicitors have previously asked for documents which are still being searched, and they are following up on those, and not everything has been received. So the cut-off point, absolutely, we can't be having documents, forwarded to the court on the day unless it's absolutely so important and it's never come to light before. Then every party is at liberty to do so. But that's why we say we really don't need a hearing on the 8th of January to determine whether these documents should be forwarded or not. You have the application in front of you. It's within this bundle. They are very simple documents and they're very pertinent. So that's our position. And if they are forwarded, then we can all have a bundle we all work with that's put into place the next couple of weeks.
Well, I'm sure then Mr. Mansfield, as with his experience as a KC bearing before us, and he is always reminded that collaboration between the parties and towards the court is something must be kept to the last minute of the trial, and I'm sure he will not resist for the sake of resistance only. And I'm sure if there is no ground to resist, then he won't resist it, because I'm sure Casey, like Ms. Mansfield, will always be bound by the obligation to cooperate with other parties. I'm sure he should not drag us into an application hearing without a strong reason. But I would shift the mic to him now to defend himself. Mr. Mansfield.
Thank you, Your Excellency. So I'd like to deal first of all with the question of mode of trial and the timing of trial, then very briefly with timetable during trial, and then there's a point that my learned friend made about Mr. Houghton and his witness evidence, and then finally I'll turn to the disclosure issues, if it please you to deal with matters in that order. And Your Excellency, we'd put in a short skeleton argument really just as an agenda to work through of issues that seem to us to be material for the court to case manage today. On mode of trial, Your Excellency, we are content. I mean, we are largely guided by the court, but we're content for a remote hearing. It's not at all uncommon in this jurisdiction and others for matters of contested fact in the discrimination and whistleblowing arena to be dealt with remotely. The pandemic has forced that upon lots of courts to have to deal with. I hear what you say and had anticipated, Your Excellency, the issues with the court in having an in-person hearing. We have no difficulty with a remote hearing. I'm extremely troubled by the suggestion that the trial date be moved at this late stage. And I note, in fairness, Ms. Malik floated that as a point that she doesn't have instructions herself on from her client. So whether I don't see that as a live application to postpone, but were it to be, what I say is this trial has been fixed since April 2023, when a case management order was made, and the parties have been preparing and getting ready for a trial in January. Myself and Mr. Kemp, my junior, have been briefed and are prepared on that basis. Costs have been incurred on the basis of a January trial. and witness availability, whether that were to be in person or remote, they've still got to be available to give evidence on particular dates. So I had not anticipated any suggestion of the date changing coming up. I would need to take instructions on all of those issues, but I can tell you from a start that I'm told in the brief message that I've had from my instructing solicitors, obviously we're not in the same room for this hearing, but we're in communication, that our strong preference is to continue as scheduled. And certainly looking at my own diary, which is the only thing I'm able to do whilst we're in the hearing, I would not be able to accommodate the dates moving within the timescale you suggested because of other both commitments at the bar and sitting commitments of my own in the first quarter of next year. We are 6 weeks away from a trial that's listed for 6 days. To move that now, I say inevitably is going to lead to inconvenience and cost, because there will be additional cost of the dates changing. So we strongly object to the trial moving, and we invite you to continue with the remote hearing, as the court's already indicated as recently as the 16th of November on a paper application by the claimants. The court indicated that the trial is going to continue remotely. So, Your Excellency, that's what I wanted to say about mode of trial. On trial timetable, it's right to say for Ms. Malik to point out what the case management order said in relation to agreeing a trial timetable, but at the same time, Rule 26.75 requires the parties to try to agree a trial timetable before the PTR, and that's what we've done in order to assist the court and so that we can be clear on issues of witness attendance. My learned friend is right to say there is not a massive amount of disagreement between us, and Your Excellency may think that it's not an issue, the fine-tuning of which we need to decide today. Attached to our skeleton arguments, and it's at page 275 of the amended bundle, is a comparison that my solicitors have produced as to the differences in timetable. And you'll see there our suggested timetable in the fourth column, and the final column on the right, the claimant's suggestion. The areas of disagreement between us are really how long we will have for the claimant's cross-examination, whether that would need to be finished on Tuesday, the second day in the morning, or whether it can span through the whole of the day on Tuesday. You'll see in square brackets on the Thursday a reference to Richard Houghton. He's not going to be called. I'll come back to him in a moment. The knock-on issue then is whether we had anticipated that evidence would finish on Friday the 26th in the morning session, leaving the afternoon session clear, so that we've got all of the evidence finished by the time we go into the weekend and we can deal with closing submissions on Monday the 29th. The claimant's suggestion anticipates that the last of the witnesses may be required on Monday the 29th, possibly broken over from Friday to the Monday. Our position is, at first, it would obviously be undesirable for a witness to be in the middle of their evidence over the course of the weekend, but in any event, it will be helpful for whichever of our witnesses. The last of our witnesses are relatively short, Your Excellency. We're talking of 4 or 5 page witness statements if one excludes the signature page and the total. Some of, even were you toward a hearing in person, I appreciate you haven't done at this stage, but were there to be a hearing in person, we will be making application for a number of witnesses to give evidence remotely in a hybrid hearing, because they give short evidence, and due to largely childcare and health caring responsibilities of their own for their own family, it will be difficult, and we say disproportionate, for those witnesses to attend a face-to-face hearing in Dubai. So whilst I agree with what my learned friend says, that we might not need to fine-tune exactly who's giving evidence at what time, the things that it would be helpful for us to have Your Excellency's guidance on is, first, how long we can anticipate being able to have to cross-examine the claimant, and second, whether evidence is going to be run into Monday the 29th, so we can plan our witness attendance. So those are the points on trial timetable. Mr. Houghton is, perhaps, if I can use the expression, a bit of a storm in the teacup. Given the pleaded allegations in the claimant's case, we didn't think it necessary to call Mr. Houghton. He's a gentleman who dealt with a grievance, but the grievance itself speaks for itself. You can see the grievance report and submissions can be made about it. We didn't think it necessary to call him. Having seen the claimant's witness statement and a few paragraphs of points made about Mr. Houghton, we reflected on whether we might put in a reply witness statement from him, but then we decided that we wouldn't. So we aren't calling him. That's our decision, and he won't interfere with the trial timetable. That brings me to matters of disclosure. I'll just deal very briefly with the position on what we flag as potential disclosure requests that we make of the claimant. And that's not live for today for you to determine. We just wanted to flag it with the court. The position is this. We had asked for two categories of supplementary production from the claimant, one about documents that go to mitigation of his loss, and the other about notes of his own that seem to go to support some quoted passages from conversations that he makes in his witness statement. The claimant's solicitors provided us with some documents last week. All we're saying at this stage is that those documents themselves beg some questions, and having seen them, we would want to think about them and whether we've got some more things to ask about that. And if we need to make an application, we will, but I don't want to trouble you today about that. So the only issue arising out of disclosure that we would want from the claimant at this stage, as the proceedings goes on, are matters arising out of what they provided us last week. The position in relation to the production that the claimant seeks from my client is quite different. An application was uploaded last week seeking extensive disclosure production in 5 categories. And we say, first of all, our substantive position is that that disclosure is not appropriate. It's not relevant or necessary to determine the proceedings. But second, that is not a matter that can be determined at this PTR, and there will need to be a contested application, we say, at a hearing about it. The background to the position is that in the normal course following the case management hearing, the parties exchanged list of requested production. We reply, and 4 of the 5 categories that the claimant now seeks were included in their request for production served in August. On the 1st of September, we replied setting out our objections to the production of the 4 categories that were included, saying that they weren't relevant or necessary to determine the proceedings. So the claimant has known since the beginning of September that we would not voluntarily produce those documents. But they made an application last week ahead of the PTR, and we say that is too late to be dealt with now today. It should be dealt with as an ordinary application. There's a statement that's been filed by the claimant from her solicitors. We need time to respond to that, to set out fully why we object to the production and the difficulties it cause. And that needs to be dealt with in the ordinary way for an application and a hearing listed so it can be determined. To give you a flavour, Your Excellency, of the reasons why this is an issue, 3 of the categories of documents that that are included in the application are about grievances brought by other people, not the claimant, about their own treatment at different times by the bank. 2 of those, well, it's fair to say none of those establish facts. If any, all they would be were grievances and results of the bank's investigation into them. They don't deal, insofar as one of them includes some evidence about the way in which the claimant was treated. That's a grievance by a gentleman called Khan. We have disclosed in redacted form that grievance to show all of the points that are made about the evidence that's relevant to the claimant's treatment himself. So what the claimant wants now is evidence of treatment of other people. But that, of course, is problematic. This trial has been fixed since the spring of this year with a time estimate to deal with the allegations that the claimant makes about his treatment. It would be impossible and inappropriate to expand this trial to include a trial of how other people were treated on some sort of comparable similar fact situation is the highest it could be put. None of the allegations about the individuals are specifically pleaded, and we say are not relevant to the case. A further complication, Your Excellency, is that two of the grievances, one a gentleman called Mr. Khan, who I've just referred to, and one Mr. Adunye, have been the subject of earlier litigation. Mr. Adunye is in this court, which was compromised last year, without there being a trial or any findings found, and Mr. Khan in employment tribunal proceedings in England some years ago, which were withdrawn by Mr. Khan. So it would be extremely difficult, this is the point that we would make on a fully contested application, even if the court were to countenance the argument that these documents were relevant, trying to work out what to make of them and have a trial within a trial as to the substance of the points made in them would completely change the landscape of the trial. And we would invite the court to allow this application to proceed in the ordinary way to a hearing so that we can fully set out our position in relation to it. The other two categories of documents, we say we don't understand the relevance of or how they fit into the case, and that will need to be fully defended as well. So that's what I say in relation to the question of disclosure. And Your Excellency, unless you have any questions, that completes what I want to say to the court just at the moment.
Oh, no, thank you very much. I just heard from you. I mean, it's almost the answer what's in my mind. Well, the first things are we dealing with is the trial mode. Well, I understand your alternative cases, which you just brought now, Ms. Malik. I mean, you just surprise us that he wants to shift and move the trial for another month. And that is something, as I said, it's no problem. It's not a problem for me, but I mean, considering, I say, I would like to remind you, say, this is a employment cases at the end of the day for a individual. I mean, Ms. Malik, I really would like to remind you, cost is an essential thing you need to be reminded with. I understand you're dealing with maybe a bank, you know what I mean? Like I could drag this case for forever, but I mean, let's say let's be worried about your own client. I mean, you know what I mean? I would really advise you that, I mean, you keep your clients' pockets, I mean, protected. I mean, from the bank itself. I mean, I'm not saying you might have a really case. You're gonna win this. You're 100% sure about it. It's your case. You're bleeding. Whatever you're doing. But what I'm saying, I mean, it's one of the duties that you look at this cost matter and then you try to reduce it to the minimum cost burden in your client. And the court is always advising parties that costs should be kept at the modest for clients, especially individuals like your client. You know what I mean? You didn't know how this trial gonna end up. I mean, as I said, none of you, neither myself, we know where we're going, where we're heading, what's the outcome of this trial. But I'm sure one thing is that one of your duties is that to keep the cost as a minimum. And I'm sure moving the trial again could be of a cost significance against your client. We as Mr. Masfeld said, I mean, the world, I mean, after the pandemic, have seen, I mean, a shifting toward online trial that accommodated all kind of trial, all kind of experts, all kind of witnesses, and we have no problem. I personally conducted a trial where I had witnesses from China, Russia, Brazil, and I know time difference was a nightmare for me. But we, at the end of the day, we managed. I mean, to deal with that kind of complexities. I mean, let's focus. I think most of this case really rely on claimant cross-examination. I can say this as, I mean, 60% of this trial is about claimant cross-examination, Ms. Malik. And then there is a closing, and then the submission, which is again a very important thing. And I can see other witnesses can be important to you, but let's, I mean, given the fact that the claimant is going to occupy, I mean, the claimant cross-examination plus the closing submission and the opening and closing submission would consist of the majority of the trial. Having no experts in the field, I personally don't see any really. I said my preference is to have them. I mean, I would love to see witnesses in front of me and look at them eye to eye. But it's if that's going to really generate a cost, I would love if Mr. Mansfield, I mean, make it just easy. Said, well, we're ready. We're right here. It's no issue. And I understand this is, I mean, cross-border trial. I mean, so I would think twice of your client's cost too. One of the factors, I mean, I would look into in deciding whether they should continue. First of all, we do usually preserve trial timetable. You know, that is one of the overriding objectives for courts usually. I'm sure this case management is being, I mean, built up since August till now. So this is, but by the trial date, we're gonna spending about 6 months. So, which is a really long time. I mean, time is of essence, as again for you, your client too. And again, the no difficulties when dealing with this kind of cases through online mechanism. That's one thing. I mean, I would if you just, and then the problematic is this issue you bringing this. I mean, alternative case to shift the trial to next month is a new things for the court and for Ms. Mansfield. I mean, I would just, I'll be super happy if you just agree with us that the mood of a trial continue in this mood.
Your Excellency, as my learned friend Laura pointed out, there's not a formal application. The only reason this was raised is because you yourself said and gave the reasoning why it's not in person. And the reasoning is because the court is some time away from opening, but it may or may not be by January. Then I mooted out just without taking instruction. Well, it can be accommodated. It's not a, you can rest assured that costs, and given we're a litigant, we're not a bank, we're not a corporate, are something we bear in mind massively. Also not to inconvenience the court. So I take on board what you say, but just to put it into context, the only reason it was raised was because once you gave the explanation, and you had no reason to, but you were very kind to say, well, you know, you would have preferred an in-person hearing, but because you weren't told by your IT people whether that was a goer 5-6 weeks ago, you know, you were unable to, and at that stage, you know, if the parties can accommodate something in February, you were willing to. We hear from Mr. Mansfield that he's unable to for his own direct commitments, and obviously we take that on board. There is no formal application that you're determining today. We're sounding out, given your suggestion. So I leave that there in terms of the court to decide, and I just kind of put into context why we asked for it.
I'm grateful. I'm grateful, really. Believe me, if Mr. Mansfield have shown any kind of agreement of flexibility towards the moving of a trial to the personal 1 February, I would take it happily. But since, I mean, his objections was the reason he's giving, like almost a 3 reason, like. He did not anticipate it, the late suggestion, the ease of conducting this trial, and again the cost of adjournment. I mean, taking all of these factors in account, I mean, I would stick to the current mood and to the current timetable, the trial time. I think the next issue is that the length of timetable. I see. But I've gone into this. I mean, I remember I had a witness who's supposed to give evidence in 3 days, and it ended up he's giving all of his evidence in 1 day, and that did really cut our trial time, much shorter than we anticipated. So, I mean, the witness will be in Mr. Mansfield's hand. I mean, if you finish with him in, let's say, half a day earlier, and then and then with the cut of the other witnesses, forget his name, the grievance guy, then we won't have any issues by adjourning any witnesses to the next week. So the only remaining things would be the closing submissions. And I think then from that basis, I personally don't have any issue with that. With the timetable, yeah.
It may be then that, subject to what my learned friend says, the parties can keep it under wraps, attempt to agree. Obviously, we have to agree before the actual hearing, but if we can agree once we've had reply witness statements, once the bundle is done, once parties are more prepared, it seems to be in a better position at that stage. And I think I see my learned friend nodding, so I think the parties are in agreement on that. I'm grateful for the quote.
And I can keep Monday. I'll keep Monday in case of whatever happened. Monday is yours again. I mean, so the timetable could be accommodated. If we wrap up by Friday at any time, that would be good. But Monday we must be available. And Saeed is with us here. Saeed, make sure, because in my calendar it's 5 days trial. The last days in my calendar, it's really my own calendar. It might be my fault. But it's then we will let's keep Monday reserved for this case.
Thank you.
Okay, Said, are you with me, Said?
Yes, Your Excellency.
Great, I'm grateful. And what's left is really the application. I've just heard. I mean, Mr. Mansfield has shown kind of what kind of defense he has against your production application. I don't want to deal with it now. I'm sure I will give you the chance to both consider it, both think about it again. I mean, I just want you to be both of you reasonable in dealing with the application. You have a flavor of what Mr. Mansfield could say about you.
Correct. When I'm able, and obviously I don't want to cut you, if I just may respond to a couple of the points my learned friend made on the application once you've
Well, you want me to deal with the application, Ms. Madhani?
No, I just a couple of points that were made that we say are incorrect, and obviously in reply I'd like to say, if I may indulge the court with your permission, Your Excellency.
Okay, go ahead. Be short.
Of course. If you look at it, starts up to page 252. And you'll see there's a short table that goes to 256. And the first three of those documents, Your Excellency, you'll see are the unredacted grievances of the individuals my learned friend has referred to, Mr. Naj Khan, Mr. Christopher, and Ms. Grace. He attempts to paint these as, well, we're trying to do a comparative approach, or we're trying to show how others are treated. That's not correct. One of the central allegations against the bank is the culture, the harassment, the toxicity, the way things are not taken properly, the race issues inherent, I'm going to say, inherent race issues. And for example, just to give you a flavour of the application, Your Excellency, if you look at 252, you'll see that the description of why the documents are relevant. In Mr. Khan's grievance, he states a black employee is referred to as a gorilla, as he's a black man, and statements were made with respect to the claimant and other black individuals. With Mr. Christopher Adenyai, and that's at page 253, their own grievance manager, who's not being called, says there's a huge overlap between what my client says, Mr. Lawal, and Mr. Christopher Adenyai within the grievance. So there are points and there are interlinking nexus. So to simply suggest that these are matters that shouldn't trouble the court because we're expanding the case is just incorrect, because all we're doing is bringing to the court the actual culture in the bank. We're not trying to expand allegations. We're not bringing new allegations. These documents are pertinent to show what actually goes on in the bank and includes our client. So for those reasons, even though my learned friend has attempted to paint this into a bigger matter and we're trying to somehow bring additional allegations, that's absolutely incorrect. The allegations that are already before the court in the list of issues are all encompassed within these investigations. And not only that, as my learned friend knows, Mr. Lawal was a witness to previous proceedings that have since been compromised or resolved, should we say. He cannot unsee documents that have already been seen. These are documents that ought to be before the court. There is no good reason. I'm not asking you to determine that now, but in the flavour of trying to save costs, the same way they don't want to fly to the DIFC to be examined in the name of costs. If we need to have another hearing in January, simply determine these matters, which the other side well know are pertinent, it's a waste of costs in our submission.
Well, then I can say it's your duty to tell Mr. Mansfield how important is that evidence to you and how relevant it is, and how, to what extent you have the right from maybe a law or authority that to rely on this in the trial. And if you put all of that before Mr. Mansfield, I'm sure he will think twice before he make a contesting application.
I'm grateful. I think I'll just ask my instructing solicitors to make the point again. It's already been made to Mr. Mansfield's solicitors, but if they need the point making again, we're happy to do so. I'm grateful.
Well, that's fine. I mean, I wouldn't have any difficulties, I mean, dealing with this application at any stage, if you wish. I mean, yeah, but do you, I will remind you both, there will be a cost order. Anyway, is there any point that we have not dealt with yet? I mean, so we've dealt with the mode of the trial, we've dealt with the length of the trial, the date of the trial, we've dealt with the application.
Just the protocol, which again I think can be taken offline. It's a remote hearing, then looking properly at the guidance of the DFC courts and what they say. I mean, in principle, to be fair, we don't have many comments to make on the draft proposal. It seems to be in line with international best practice. It seems to be in line with the DIFC's practice. There may be a couple of tweaks here or there, but I'm sure that can be ironed out between the lawyers. It doesn't need to trouble the court. I'm grateful.
I'm sure, yeah, you should not trouble me, yes. I'm grateful. I'm grateful. I didn't need any extra troubles. I'm having enough, actually.
May I ask, Your Excellency, where the court is going to be situated? Is it going to be in the same building, the new court?
Yes, it's now the current level is we're ground level now, but we're going to be building 5, level 3.
I see. Okay.
Yeah, we already abandoned our current premises. I mean, part of the court staff would start moving next week, and then the rest would take another month to be ready. So, for example, my office won't be ready before 15th of January, so I'll be working from home until then. I don't have an office, so you can call me a circuit judge from now. I'm going around. And yes, from that basis, really, I mean, because you know the issue is contractors, and even if they give you a date when they're going to be ready, it's you need to expect the court. I mean, I'm in the middle of construction case, that a judgment I'm writing. I mean, it's all about a deadline. I mean, deadline was like changed like 7-8 times. I mean, the delay is more than 300 days delay. I mean, you understand, I mean, with constructions, things are not easy. I mean, so from that, believe me, Ms. Malik, as I said before, I mean, the courtroom was the main factor why we could not accommodate this to be in person. But next time, if you have another employee of the bank who wants to sue the bank, and if you would like to sue me and a judge, despite the outcome of this case, I mean, we can accommodate it physically.
Let's hope that doesn't happen and the bank takes stock.
Yeah, I mean, I would really remind you. I mean, I don't know to what extent you have engaged in negotiation and try to settle this case, because if you haven't tried it before, I mean, you may try do it now. And in DFC court, we have a habit of assisting parties. We can, if you would love to have to be assisted with a mediation. I mean, one of the practices with this court, like we can give you another go. We can give you an expert that can assist you trying to settle this. If you are very late stage, you think, I mean, if you didn't need it, then I understand. But I remember our Chief Justice have referred party to settlement after court first instance judgment.
It's interesting you raise the point, because 2 points arise from that. You'll see from the initial case management information, I can take you to the documents. In April 2023, one of the questions on the questionnaire is, would the parties be assisted? And my practice, even as a litigator, I always try with alternative dispute resolution, whether it be arbitration, mediation, or otherwise. And I always say, if parties can sort, they sort. If not, we fight. And we did put in there that maybe with the assistance of the court that may happen. The other side's answer, however, even as far back as April, was no. No interest, and that's in the documents before you. In a previous matter, which has since been compromised, your colleague, Mr. Justice Black, directed the parties to try and sort matters out. The DFC courts, I know, wearing my court users committee hat, are going into the kind of court annex mediation, the same we have at the ADGM, and we have been asked for views on that in relation to the draft protocols. And that's welcomed, because I think for the kind of tiered approach to litigation needs to bring in force and mediation, and we're having that generally within the UAE and the DIAC as well. Again, I say to the court that we had at the outset said, well, if the court directs it or if it's pertinent to the parties, of course we will. The other side are a resolute no. Again, a matter which goes to cost in the end, but I just flag that up now because you have the documents before you, and that's from April 2023. So I'm the practitioner that always says that if things, again, for cost reasons, and if the other side really are about costs and don't want costs of trials, I'm sure that would be something they wouldn't be saying no to as early back as April 2023.
Well, unfortunately, we are at this stage now, but I mean, we would bit late. If it's earlier, then things could be completely different. But I know we're approaching January. There's going to be Christmas and the New Year holidays, and then the preparation of the trial will going to occupy a lot of your time. Soon, I don't know. Maybe if you're both willing, I mean, if Mr. Mansfield said, well, we're willing, if you think there is a room, we could have really assist you and gave you one of the court experts. I mean, maybe 40, 50 years of experience, judge that can handle your negotiation if you wish. And but if you didn't think it's, because we didn't need to waste even everyone's time, like both of you, we need to see a really a willingness to do that. And I'm sure Mr. Masman cannot, he would need to take instructions as well. I'm sure he cannot just say, oh, I will go for it. I mean, you know what I mean? Well, I understand his position and your position. And but I like the way you said it. It's Ms. Malik. It's, yeah, your perception about this court and maybe ADGM court. And I think it's became a global trend now. I mean, most of the court, and I'm sure the English court would take similar approach. Maybe Singapore court would take a similar approach too. I've been to New York for I shadow during my couple of years of shadow New York commercial judge. I mean, and all he tried to do, even in the courtroom, the first things he tried to mediate complex cases.
Well,
yeah.
You might want to add that on your order. I'm sure Mr. Mansfield wouldn't be adverse to that, and he can then take instructions. We are where we are. If it fights, it fights, and if the parties manage to sort it, they do. That's as far as I can go. As I say, it's something that was in the court's mind and the party's mind as far back as April, but the position given by the defendant at that stage was they wouldn't be assisted. They didn't want to consider anything alternative dispute resolution mechanism. It's in the papers. We said we would. We're in the court's hands, and rather my learned friends are instructing solicitors and their client. But I think
you can see Mr. Mansfield body language said, what I'm hearing now, what's the judge and the other party saying?
Your Excellency, I hadn't anticipated on our agenda of items to discuss anything about ADR. I'm afraid the position is what it is. I accept as a general proposition what you and Your Excellency and Ms. Malik say, that some cases are assisted by ADR. I'm afraid the bank's view is this is not one of them, in the nature of the allegations that are made and our assessment of the merits of them. So there has been no application for any formal ADR process, and we say that should remain the position. But My instructing solicitors are here in the hearing. They'll have heard what you've said. We will, of course, consider the position in relation to whether there is any way forward. But I'm afraid it seems to us late in the day, and it's a matter that needs to go to trial.
Well, what I can see where he come from. He stems that power from having your witnesses in his hand for maybe 16 hours cross-examination, Mr. Malik. That's why.
I'm not sure I agree, but that you have the positions, and again, the matters that go to cost in any event. I'm grateful, Your Excellency.
Grateful. Then I think we have nothing to add to this. You have my direction about the trial mood, trial date. No movement with that. Timetable would be, as I said, accommodated. Monday would be added to my calendar. And we will read it as it go.
Yeah,
And
I would look forward for the outcome of the request for protection or the rejection from your side, Mr. Maswell. We'll see. We'll deal with it in official, or if you would like to deal with it over hearing or on paper or whatever, I'll be ready to deal with it. I mean, Saeed, our case progression officer, will be before me the earliest. And I can hear it in a short notice as well. I can assure this to you. I can hear it in short.
I'm grateful, Your Excellency. Well, we'll put in a written response, and I anticipate that we'll be asking for a hearing of that as indicated in our skeleton argument. But I'm grateful for Your Excellency's indication.
Lovely, great. Then what's left is to wish you a great day ahead and good days off until the new year, and I see you next year.
Inshallah. Thank you.
All the best.
I'm grateful. Good morning, Your Excellency.
Good morning to you.